Hi viewers, welcome to VMV Legal and Management series. Our objective is to provide tips for your success, both on the legal front and also the management front. My dear professionals, please use this and become successful in your career. In that regard, we have started several issues, several matters on our channel. Please do subscribe our channel and also press the bell icon. Never forget to comment because your comment are value additions for us to improve the quality and content of the video. Today, I am going to speak on Factories Karnataka Amendment Bill 2023. The 15th session of Karnataka's 15th Legislative Assembly passed this bill. The bill is called Factories Karnataka Amendment Bill 2023. Why it is in bill form? Why not an act? The Legislative Assembly has passed it, then why it is not an act? Let me tell you, my friends, the Schedule 7 of Indian Constitution classifies the powers of union government, state government, and also there is something called concurrent list. That is union list, state list, and concurrent list. Factories come under concurrent list. That means the responsibility lies with the state government and also the union government. Therefore, President assent is required if you amend any sections or any part of the Factories Act. Anyhow, the bill is passed in the Karnataka Legislative Assembly and it is sent to the President assent. Once President give an assent to the bill and it is gazetted by the appropriate government, it becomes an act, it becomes a law. But what are the contents of that? Let's understand. But even before that, let's understand why this amendment. India is the fifth largest economy in the world today. It is heading towards the second largest economy to become the second largest economy in the world in next 25 years. By 2047, India would be the second largest economy. For that, you need to do some amendments. It's not a magical wand to say that you become the second largest economy today and tomorrow you are second largest economy. It's not going to happen. Therefore, certain amendments have to be made on the law front to create an environment for investors to invest in India. And Karnataka industrial policy wants investments to come into Karnataka. It wants Karnataka as a destination for investments. And that is how these amendments are made to the Factories Act. So, now what are the contents of this bill which would become an act after the assent of President? Section 54, the daily working hours. In the act, it is 9 hours a day or 48 hours a week. Now in the bill, which would become an act, what it says, that is no worker is allowed to work beyond 12 hours a day maximum, including the rest, and not more than 48 hours a week, and also the remaining days whatever he works should it should be considered as paid holidays. That is what it says. Section 55, what it says, the intervals, when the intervals have to be given. The act says no worker is allowed to work beyond 5 hours without interval of rest. Now, what does the new bill say? It says no workman is allowed to work beyond 6 hours without interval for rest. So an interval of rest should be given at 6th hour. That is after working for continuously for 6 hours, an interval of rest should be given to the worker. This is what the new thing says. Then the spread over, including the rest period, the act says that no worker is allowed to work beyond 10.5 hours, including spread over. So rest has to be given and including that rest 10.5 hours. But what does the new law say? The new law say inclusive of rest, the spread over is up to maximum hours of 12 hours. So this is the amendment to 56, section 56. Now section 59, extra wages for overtime. The act says no worker is allowed to work for more than 48 hours a week and not more than 9 hours a day. If a worker works beyond 9 hours a day or 48 hours a week, then he is eligible for overtime wages at the rate of twice the rate of basic wages and other allowances. It is twice the rate of wages, in other words. So what does the new amended amendment says? Amendment bill today, tomorrow it would be an act once the president gives an assent. So no worker is allowed to work beyond 9 hours a day and beyond 48 hours a week in the 6 days working pattern. So if a company is working for 6 days, that is Monday to Saturday, then the worker is not allowed to work beyond 9 hours and 48 hours in a week. That's point number 1. Point number 2. In 5 days working pattern, no worker would be allowed to work beyond 10 hours a day and 48 hours a week in 5 hours pattern. 5 days pattern. If the worker works beyond that, what it is, I will tell you. Now, in the 4 days pattern, I don't know how the roster would be prepared by the HR fraternity. We have to see that. If any worker works beyond 11.5 hours and 48 hours a week, then such persons, that is in all the 3 cases, such persons are eligible for the payment of overtime at the rate of twice the rate of wages, that is the overtime wages. So extra wages for overtime, if somebody works beyond 48 hours, in all the 3 cases, 9 hours, 10 hours or 11 hours respectively, then they are eligible for overtime and overtime wages. So when you pay the overtime, when you allocate the overtime here, you need to have the consent of the worker. Please note that HR professionals, you should need to have the consent of the workers. Without consent, if you ask somebody to work, that amounts to exploitation. So you have to take the consent. And if somebody is working on the paid holidays, because now I have said 4 days pattern, 5 days pattern, and of course 6 days pattern, for the first day would be an holiday and remaining 6 days he would be working. That's there. But in the other patterns, 5 days you would get 2 weekly offs, 2 weekly holidays. Sorry, in the 4 days pattern, you would get 4 days, 3 days weekly holidays. So if a worker works on the weekly holidays also, he is eligible for overtime wages at the rate of twice the rate of basic wages. Please understand this. Consent is required from the worker. Don't ignore that part, because once that becomes an act, once it is implemented, these are the things you need to know. Then section 65. Section 65 says, no, it says the overtime limit, it restricts the overtime limit to 75 hours. Now with an exemption by the state government, the maximum overtime working in the current act is 75 hours. But in the new law, that would be 144 hours. Again, here you will have to obtain the consent of workers to allocate him the overtime. And also you will have to take the permission from the state government. In this case, it is Department of Factories and Boilers. You need to take the permission from them, and only then you can allocate the work to the worker as far as overtime is concerned, and you will have to take the consent of the worker. That's most important. That's the new insertion in the new law, new act, once it becomes an act, of course. So that's the amendment. And further, section 66, there is a broader and greater amendment in order to give women equal opportunities for work. What does that say? Because there are 16 points, I will read it out from the Gazette itself, which is here. This is the official Gazette, which I am showing it to you, and I will read it out to the official Gazette itself. Now, section 66. Further restriction on employment of women. The provisions of this chapter shall, in their application to women in factories, be supplemented by the following further restrictions, namely: A. No women shall be required or allowed to work in any factory except between the hours of 6 a.m. to 7 p.m. That means all women are allowed to work between 6 a.m. to 7 p.m. That's the first thing. Now, what is the difference? Existing law also speaks the same thing. But the further things, whatever I am going to tell, that's most important. Provided that a woman may be required or allowed to work in any factory between the hours of 7 p.m. to 6 a.m. subject to the following conditions. There are 16 conditions that has been laid down in the bill, which would become an act after President's assent. I'll read out all the 16 numbers. Please listen to that. It shall be the duty of the employer or other responsible persons at workplace to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, statement, or prosecution of acts of sexual harassment by taking all steps required. See, this, whatever this point and the subsequent point I'm going to speak, it's already there under the provisions of POSH, that is Prevention of Sexual Harassment at Workplace 2013. The law, that law already covers. You need to have a machinery, grievance machinery. You need to have internal complaints committee. Whether there are women working in your organization or not, even visitors, somebody who comes from outside, they also could be exposed to sexual harassment. Therefore, internal complaints committee in every organization, irrespective of women working or not, is primarily required. And in this case, it is related to only the workers who are working. I was talking about the POSH. Now this, whatever I read through, is only related to the women workers working in your organization. The second point, express prohibition of sexual harassment in any form such as unwelcome sexually determined behavior, either directly or by implication, or advances or contact to gain contact, or demand sexual favor, or make sexually colored remarks, or showing pornography, or any other unwelcome verbal, non-verbal contact of sexual nature. So none of these things a worker is supposed to do. Any acts of which I stated just now, if a worker does, you will be subject to punishments. But it is the responsibility of the the occupier and factory manager to see that these things doesn't happen to any workman in the workplace. Point 3. Provide appropriate working condition in respect of works, leisure, health and hygiene to further ensure that there is no hostile environment towards women at workplaces, and no women employee should have reasonable grounds to believe that she is disadvantaged in connection with her employment. The fourth point, the employer shall maintain a complaint redressal mechanism in the factory itself, and the said mechanism shall ensure time-bound treatment of complaint. Such mechanism shall provide, when necessary, a complaint committee, a special counselor, or the support services, including the maintenance of confidentiality. Here, confidentiality of any grievances of women has to be maintained. You cannot disclose many of the things like email ID, phone numbers, all these things. Any of subsequent clauses do mention of that. Now, the fifth point. The female employees shall be allowed to raise issues of sexual harassment to workers in the workers' meeting and other appropriate forums. Okay, she can raise the complaint, raise an issue in various forums. The employer shall provide proper lighting and CCTV coverage not only inside the factory but also surrounding of the factory and to all places where the female workers may move out of necessity in the course of their work. CCTV footage shall be stored for not less than 45 days. Whether you store in local server or in cloud or whatever form, 45 days you will have to keep the storage. Please tell your IT counterparts to maintain this because they would speak of budget and XYZ things. You, all of us HR professionals, please insist upon this. Once this becomes a law, you are liable to keep all the video recordings for 45 days. Any untoward incident to the women, if you don't have the record, you will be violating the provisions of law. Therefore, please ensure this. Now the next point. The employer shall see that the women workers are employed in a batch not less than 10. So the women workers should be at least 10 members. You can't have 9 people, 9 women workers working in the night shift. They should be 10. Minimum requirement is 10. Please ensure this. See, the companies, the production, all these people, they insist for achieving their productivity and production. They insist to have whatever number of women you have. You as an HR professionals, please tell them that 10 women are required in night shifts. Okay, these are the restrictions put by the law. Once it becomes an act, that would be a serious thing. Then, sufficient women's security shall be provided during the night at the entry as well as exit points. Sufficient number of restrooms shall be provided for the female workers to arrive in advance and also leave after the working hours. The employer shall provide transportation facility to women workers from their residence and back for the night shift, and security guards including female security guards, and each transportation vehicle shall also be equipped with CCTV and GPS. That's important. Please ensure that you tell all your transporters to install CCTVs in the vehicle and also GPS to the vehicle, because tracking is very, very important. Very long ago, there was a Pratibha case in HTMT. This is somewhere around 2006 or 8. I don't remember the exact year. A driver, assaulted her and killed her. He abused sexually and he killed her. So after that, many changes in the laws have come as far as women are concerned. So please, the risk is there as far as safety of workmen is there. Please ensure this point. The vehicles, because rest of the people would be on your roles, so they would certainly have little of accountability, but drivers who in the cabs, I don't think they would have the same amount of accountability as others in the organization have. So it's not only that, you should also have their background verification done, which is there in next couple of points. I would read it out. During night shift, not less than 1/3 of the strength of supervisor, shift in charge or foreman or other supervisory staff shall be women. So 1/3 of the population should be women at whatever levels they are. There shall not be less than 12 consecutive hours of rest or gap between the last shift and the night shift wherever a women worker is changed from day shift to night shift and also from night shift to day shift. In certain cases, I'm not telling a specific industry, in certain cases, people are asked to continue the shifts, violation of law. That particularly when there is a 12-hour shift and in the security, this is done. Now you can't be doing that as far as workers are concerned. That becomes violation of the provisions of law. Next point, the establishment shall obtain biodata of each driver and conduct pre-employment screening of the antecedents of all drivers employed in their own. As regards the driver employed through outsourcing, the company shall ensure that to its satisfaction that the collection of biodata and conduct pre-employment screening of antecedents of the driver is carried out by the service provider. My dear friends, let me tell you, don't just go by the police verification of from the commissioner office or the SP office, as the case may be, because that's not going to give you the full picture. please check their court records. As for it's not only for these drivers I am telling, even rest of the workers, you please, workers or any employee as the case may be, please have the court records verified. Today there is mobility, too much mobility from different parts of the country. You don't know what type of crime you would have committed elsewhere, so there is a possibility of threat. Therefore please check the court records verification, then you shall be really doing the justice to what is required by the law. It just if you do BGV, you pay some that is BGV is background verification. You pay the required fees to the commissioner of the police. They will give a report within the jurisdiction. They are not going to give you the detailed report of everybody. So therefore, do the court verification. There are a lot of companies who do background verification. You choose whatever you want, but ensure that you do that. Next, the telephone number, particularly mobile phone numbers, email ID and address of women employees shall not be disclosed to unauthorized person. So the confidentiality has to be maintained because it affects the dignity of women and also the privacy of women. It's not only women, you cannot disclose anybody's contact details to anybody because it affects the right to privacy under the Constitution of India. You cannot disclose anything unless somebody voluntarily gives, that you don't have control. Careful selection of routes shall be made in such a way that no women employees shall be picked up first or dropped at last. So route list very cautiously you have to do. It shall not be made compulsory or obligatory for any woman worker to work in night shift. Written consent, I repeat, written consent shall be obtained from the women workers who are interested, I repeat, who are interested to work in the night shifts. So note this point, you cannot compel, you cannot force women workforce to perform duties in the night shift. Be cautious of these 16 points because if you follow this, then you are at a safer side. If you don't follow this, then you are really going to face the problem in future. Having said this, there is another clause, there shall be no change of shifts except after weekly holiday or any other holiday. So that is there and it will continue to be there. So with this, I conclude my talk on the Factories Karnataka Amendment Bill 2023. Thanks for watching this video. This is Mahesh Mahadevaya with my associates Miss Vinolia and Mr. Vinay for VMV Legal and Management series. Please do subscribe our channel and press the bell icon. Comments are very important. Please comment on the comment box. Thank you very much once again.